My name is Renata Avila. I am the CEO of Open Knowledge Foundation. I also am a lawyer. I have been a lawyer since 2004, so it's a long time. And we have this all-women panel discussing okay, apologies, we will continue. This panel will be about surveillance against lawyers. I will start by telling you a little bit of my experience with surveillance and direct surveillance targeting me and how it has evolved over time. And then we will discuss a very concrete case. There were more panelists announced, but they are like busy working on an emergency in one of their cases. So they apologize for not being here. But I think that we couldn't lose this space and opportunity to discuss about this very important topic. Basically, I graduated from law school in Guatemala, and then I started working on a human rights case on genocide. And we were like investigating basically the most powerful generals in the country. And at that time, it was very interesting because at that time we started using computers, and we started using, mobile phone was not a thing still, but we started using computers to try to write in a more efficient way. We started to communicate by email and so on. And we were very, very, very aware of being watched because back then, surveillance was physical. You will know that the beggars that were outside the office were not actually beggars. Were paid, the people taking care of the cars, the people like in the corner, everybody. We know that they were paid to watch all the movements, to take notes of who was coming into our office, out of office, and so on. We knew as well that we had to be like very, very careful with our papers because we, at that time, we were not relying so much on digital files. Everything was printed, everything was carried with us. And we were keeping the testimonies, I remember putting the testimonies of the victims under my bed, making sure that nobody will have access to them. At that time, the surveillance and the collection of information methods were very, very different. What would happen, and you can review, the Inter-American Commission of Human Rights reports, you could review the national reports on human rights violations. What they used to do was to raid the offices of NGOs and basically take everything they could from our desks. And they will take, the entire computer, because at that time, we didn't have laptops. And we were very aware of the surveillance. We were very aware of the increased, how easy it was to survey digital and so on. So at the time, we had the support of many collaborators from the technology community showing us very basic encryption and showing us that, you didn't have to have decentralized information on your CPU. So we had a central server that was hidden in a part of the office. We had some measures back then. And we also had some measures of try to disguise and print different versions of the documents that were not the real ones. We had some techniques to protect ourselves. And I was very proud because one night they raided our office. They, as only identified masked men raiding an office in the middle of the night. Even we had some surveillance camera. Of course, you couldn't see anything. And I was very, 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 very happy and proud because all my team, all the legal team and paralegals investigating the case were very careful. Everybody, they took empty CPUs. They took senseless information, so we were safe. But then, everything changed. We got donated some laptops, and we started taking the laptop with us. We started using mobile phones. We started we started getting used to carry all the most precious information as a lawyer in one device. And that really changed everything. And paradoxically, and you can see everywhere, all over the world, the data of human rights violations and raids against offices. Mysteriously, all the raids started to go down, 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 down. Because somehow it was not necessary any longer to go and raid the office and take all the files away. They could access them very easily without us noticing. And I think that, like in that reflection, when you see how we lawyers, have moved from relying on paper and being very private with our information and locking it at the office and making very sure that only few people have access to our files, to a shared cloud-based system in the law firm, to a shared system of everything online that we think that is secure because we put a very long password on it, but it's not. So I had a very interesting encounter in around 2007, 2008 with Julian Assange. And we were talking about archives at that time. Archiving is also a very important topic for lawyers that is not, it is related to what we are discussing here, but it was not relevant for this conversation. And we became friends, and we became increasingly aware of this difficulty and tension between, the exercise of legal profession and the increased invasion of the privacy of lawyers. I ended up volunteering and doing pro bono advice for WikiLeaks and Assange, and it was, I have never in my life felt so watched and so monitored than during this period of time when I was intensely collaborating. Because when you are the lawyer of one of the persons who is most aware of global and local digital surveillance, he will make you aware of every possibility of surveillance that you are under. So I remember when he was still, with restricted freedom, we will have to go on, and there's documentaries about it actually, we will have to go through long walks in the middle of the woods. And in spite of being in the middle of the woods and being not surrounded by anybody, you will have to write very carefully and not even say a word, write very carefully in a notepad the ideas that you had for his legal defense. That was the level of, and actually, that was the way that each and every lawyer anywhere dealing with a politically complicated case should have been doing. And it was out of ignorance that many, many lawyers dealing with very complicated cases were doing the things in the open because they didn't know how to encrypt. They didn't know that actually it's very cheap to bug your office and install a microphone. They didn't know how sophisticated the global market of surveillance tools available for private and public actors was 10 years ago. And now we can only, now we know. 10 years after, after the Pegasus scandal, after many other things, the Snowden revelations and so on, we have seen how many cases have been completely being abused because lawyers that are working on those cases are under surveillance. We have to question whether those cases are fair trial or not, which is a conversation that we are going to have today. Well, the thing got more complicated for lawyers defending Assange when he obtained political and diplomatic asylum inside the embassy of Ecuador in London. In theory, embassies are places that you cannot violate. Violating the privacy of the people inside an embassy, and I imagine that we'll expand on that, is unthinkable. But there, we couldn't go for long walks in the middle of parks anymore. We had a very, very small place, which is, it was almost the size of this room, with a lot of people surrounded by police 24 hours a day, and with police inside. And that was the space to operate, a team of, I think that at some point 25 lawyers, operate and try to have a private conversation with the client. So I will pass the floor to Deborah, who will take us to that place and tell us the experience and tell us the legal implications about it. Over to you.
Good morning, good afternoon. Like Renata, I agree, it was so much more. I long for the days when we had raids by unidentified masked men and we knew that we were under surveillance as lawyers, and when documents and information was seized so that we could at least act on it accordingly. The situation that we've had as counsel for WikiLeaks and assisting in support of Julian Assange is that this was all clandestine. And my personal experience was as a media lawyer visiting Julian Assange when he was taking sanctuary at the Ecuadorian embassy in London between the years 2012 and 2019, when Renata said that there were police surrounding the embassy. We certainly knew that. Those were UK police. They were uniformed. What we didn't know was that there were undercover CIA operatives in vehicles around the premises. What we didn't know was that the security inside the embassy, who we believed to be the security engaged by a friendly government, the Ecuadorian government, who had given our client sanctuary, who granted asylum to Julian Assange. We believed that the security inside the embassy by uniformed security officers were Ecuadorian security people engaged by the Ecuadorian government to provide security to our client and to us as visitors of our client. What we learned only in 2019, after Julian was violently and forcibly removed from the embassy and incarcerated in maximum security prison in Belmarsh, what we only learned then, as a result of whistleblowers inside the Spanish, as it turned out, Spanish security company that was in fact providing security at the embassy, was that the security guards were not Ecuadorian employees. They were in fact employed by a Spanish company, UC Global, who had been increasing its digital surveillance of visitors to the embassy and providing that information to CIA operatives in the United States. And this means that lawyers such as Julian Assange's US criminal defense lawyers, Michael Ratner, who's since passed, and Barry Pollock, who took over, who will be representing Julian Assange in the event that he is extradited to the United States to face criminal charges. Lawyers that will be representing him in that criminal case, meeting with Julian Assange inside the embassy to discuss his US criminal case when they handed over their cell phone for safekeeping and their laptops if they brought them, to the security guards outside of the meeting room. Unbeknownst to them, the security guards from UC Global, taking instructions from the CIA, the US government that's prosecuting Assange and seeking his extradition, they were basically downloading information from the cell phones, taking photographs of the SIM cards, sending information from the conversations that were bugged inside the embassy directly to the CIA. So it's of huge concern. It's of huge concern, the levels on which the surveillance was going on. And this is a breach of fundamental due process rights, fundamental rights, both of Julian as a potential defendant in the US and of the attorneys who visited him, who were unaware at the time that this was going on and would certainly never have brought in the precautions that Renata referred to in terms of the sort of things that one could do to protect themselves prior to digital surveillance, such as keeping your papers stuffed under the mattress and having different versions, etc. Certainly, had we known that our cell phones and other recording devices and laptops would be searched as opposed to just held for safekeeping inside the embassy, we never would have brought them to the embassy. I mean, that may not have been sufficient protection. Charles Glass, who's a national security journalist who interviewed Julian Assange in early 2019 at the embassy, his hotel room was raided and his computer was stolen shortly after his visit. So the surveillance wasn't limited to the embassy, but the point was that, first of all, Mr. Glass was aware when his hotel room was raided. And second of all, in the embassy, we were under the impression that the security was for the safety of our client and friend, Julian Assange, and for our security as visitors of Julian Assange. We had no idea that these were operatives and agents of the US government that was prosecuting our client.
I want to add to what you mentioned, and we will go back to that. Also, the psychological impact it has on you as a lawyer, in general as a lawyer, because I think that the one thing is your ability, like to have a private conversation with your client, which should be like, like not able to be violated ever. The second is also your duty, like it is so complicated because you are always afraid of saying something or that might affect your client later. And you go back in time, what if I had like all the legal strategy on my telephone and now the other party has it? Or am I risking, because I have a client that is, highly politically exposed, am I risking all my clients as well? And it is so frustrating to not to have, like, in many of the legislations, there's no mechanisms and there's no ways to seek reparations even, for these, psychological damage and, like the even economic damage that it does to a client to have the lawyers under surveillance. But we have, this conference is very relevant because we are like in the process of identifying the legal, loopholes and the legal deficiencies that we have in the Latin American legal frame and the global frames. And we have, we are lucky to have here Professor Daniela Elleberg, who is going to also to go on a bigger picture on all of these. And then we will go back to you to also hear from the U.S. perspective on how does it play in a fair and a free and fair trial.
Thank you so much. Good morning, everyone. Good afternoon, Ms. Deborah. So thank you for this opportunity. I think this is a huge dialogue, an important dialogue, and mainly it is important also to share our experiences in our countries and to see the similarities and also the differences. I would first, we received some questions, and reading all these questions for the panel, I thought about answering them with one question also. And that will be, are there similarities between the old surveillances in totalitarian governments and the current surveillances on human rights defenders who are criminalized through criminal techno-surveillance? And I would say there's even if they are separated in a politically scenario, from a politically polarized scenario, the curious thing is to turn to the 50 years ago and realize that how the surveillance situations were configured in the same way that the digital surveillance can be evidenced in current times. So if we see, we can evidence this when we see to the jurisprudence of the Inter-American Court of Human Rights. We can see 8 cases, for example, that are addressed covering questions of criminal evidence and illegality, and 2 of them is specific to telephone interceptation or privacy, addressing to the questions of illegality of the means of obtaining evidence. For example, so these cases are Los Hermanos Gómez Paquiwari versus Peru, Acosta Calderón versus Ecuador, Lori Berenson Mejia versus Peru. In Brazil, we also had the important case of Asher versus Brazil, Fontevecchia d'Amico versus Argentina. So these were important cases in which we can see these differences, but also similarities between this surveillance that could be seen with, in these cases that were in dictatorships, and these current cases that we can see nowadays with digital surveillance. So I think listening to your words, I would say that in terms of mechanism of, for example, important possibilities of actions for authorities that should be taken, and just these possibilities, we could say that the need of an independent body or judge to supervise these surveillance measures, contemplating the so-called Republican principle of checks and balances. So we need this independent body, we need this supervision of these surveillances, and also the demarcation of some characteristics of the act of surveillance that are essential for the to configure, for example, lawfulness that usually we can't see in these cases actually, but legal provision, purpose, proportionality, usefulness, reasonableness, opportunity, necessity, and also judicial guarantees, as you said, due process, they are really important. So I would bring to you our reality in Brazil by saying that the national security speech is a worrying point in countries where the authoritarianism has grounded the state building. And Brazil is one of the Latin American countries that has been unable to fully reach the democracy transition. So it is not coincident that our Code of Criminal Procedure is from 1941, a time of dictatorship here. It is exactly with this regard of this authoritarianism heritage and the structural racism that we have here in Brazil that we should face the criminal procedure and the new technological advances in terms of coercive measures and means of obtaining evidence in our criminal system can turn out to the lawyers, for example. So this is probably, that is probably the reason why, or even the consequence of, we can identify national security ideology on criminal procedure, which seems to assume the same security point of view in terms of coercive measures and means of obtaining measures, means of obtaining evidence, sorry. So in Brazil, we see these misunderstandings among the concepts and limits of national security, public security, criminal procedure, and criminal investigation competences. So we see all this fuzzy area. We can't, these misunderstandings sometimes are in purpose. And so it is truly important to develop some mechanisms to, how would I say, to stop this, I would be actually static, and I won't say this will stop, but at least to develop some limits and to our society in terms of due process of law, and so we could do, for example, to in our position of, for example, criminal defense attorneys, and not being under surveillance. So this is probably, I think, globally we see that this movement that governments use intelligence resources to establish political surveillance in the name of national security and in the name of public security. And this is why I told you, I think this, this authoritarianism heritage in our criminal procedure, Brazilian procedure, it's a really important thing to pay attention, because we all know that this is something that was all was in the since the 50 years ago when we saw in the dictatorship. So we all know that the pandemic and this digital era just catalyzed something, just enabled the visionless of what we already set up. So I would make this first, I would call the attention for these points, and just to emphasize the need to protection of fundamental rights, and to present a little bit of our situation here in Brazil with a criminal procedure code from the dictatorship, with a country that still has not was not able to reach the democracy.
Thank you so much for the example of Brazil, and also I think that is very relevant for this conversation, the jurisprudence of the Inter-American Court on Human Rights. And sadly, the case of surveillance against lawyers is not unique to the Assange case, is not unique to Latin America, it's everywhere. So I think if we look at the situation in Brazil, I'm familiar with the cases of surveillance of Valesca Zanin and her husband in the Lula case, for example. I'm familiar in Ecuador of the surveillance of all the lawyers of the political prisoners. I'm familiar with many other cases of lawyers under surveillance, even, even interestingly, even for family matters, like in family matters, it's very frequent of, hiring private security firm to surveil on everything the lawyer does to, for child custody, on very, very complex private matters. The point is, when we go to a trial after the other party and especially when the other party is the state, when the other party listened to private conversations and saw all our cards, can we speak about a fair trial? Can we speak about due process? Can we speak about rule of law? That question goes to Deborah and then to you, and I will like to hear your reaction to that, because I have an opinion on that, but I would like to hear first your opinion, and then maybe we can open the conversation about discussing that.
I think that's really the key point, is the lack of accountability and the free rein that the government then gets to use the information that it gleans from this sort of illegal surveillance in even criminal trials. Daniela's point about how we need to have some kind of an independent body that supervises the surveillance of governments around the world is very, very key. But it's also important that such a body has teeth and that it has the ability to mete out penalties that are meaningful. In the Assange case, for example, the government position is that the CIA is part of the executive branch. It is part of it is an institution that is separate under United States law from the Department of Justice, which is the arm of the government that prosecutes Julian Assange. And so therefore information collected by the CIA will not be passed. There's a Chinese wall, they call it. They won't pass that information that they collect for intelligence purposes over to the Department of Justice for the purpose of prosecuting Julian Assange. But all that that really means in practice is that the Department of Justice won't be able to use the actual tapes, the actual information gleaned as evidence in a trial against Julian Assange. It does not mean that the government prosecutors aren't learning things that they can then pursue and get the same information from perhaps more legal sources to use in trial. So it's a facade. There really is no protection, and there's no accountability, and there's no way to get a fair trial when the government, it's the same government, has all this information. Whether they actually use the illegally seized information as evidence against you is irrelevant if, as a result of whatever they hear, they then go find evidence that they are allowed to use. So there's no accountability, and and there's no consequences for governments illegally surveilling potential criminal defendants and their lawyers.
And it is really worrying. It is really worrying that, in many, in law enforcement and in intelligence services, many times other countries just copy the policies of the U.S. So basically, probably it is the case, and I will invite my colleagues here attending. It will be a very interesting investigation to see if that fictional Chinese wall theory is what applies to all intelligence services all over the world, or at least in Latin America. Probably is the case, and probably we haven't looked into it. Probably, intelligence is part of the executive, is spying on the lawyers investigating a tax fraud of the high officers. They get all the information, then they clear the evidence. If I'm thinking about my country, how they will operate in practice, it would be very, very interesting, to see this. And then again, that's why we need to fight when we are passing privacy and data protection laws. We need to fight against the national security exceptions. It is not about saving us from terrorists. It's about us being vulnerable to intelligence services. So I think that once again, the Assange case is really showing us the importance of reform, the power of the people, and the power of the state, and the power of privacy as well, as a tool to defend us. So in that line, I would like to hear your opinion of that. If, for example, you were litigating a case and you are finding out that you are under surveillance, can you here in Brazil use any mechanism to protect your client and claim that the trial will not be fair because of you are under surveillance, or is not possible?
It depends on what do you consider possible or not. In terms of if you discuss in a serious way a criminal procedure, you could argue that it was an illegality, and you could say it can be null. So, but in what I would actually point, it's the fact that we also have some little, I would say actually, the strata that exists under the surveillance. Because I'm not saying that we are not all watched, but what I want to say is that some data collected from this surveillance are more important and tend to come from certain bodies. I would say this surveillance, nowadays when we can see in terms of, for example, search and seizure in cell phones, we can say that this would happen without the legal, without the judicial guarantees for people here in Brazil, black people, for example. But what I would, why am I talking to on this? Because I think that some lawyers, some attorneys are more targeted than others. And I would say this because we are all under surveillance, but there are one that are in potential more, the data that were collected from them are in potential to be used more than the others. And I would point this, for example, for human rights defender here in Brazil, we are reaching, I think, the first place of killing human rights defenders in the world. And here we have this situation that were, I think it was in 2018, the situation of surveillance of human rights defender from the movement, indigenous movement, and environmental rights. So I'm talking about this just to say that I don't believe that there are some cases that we can't say there are judicial guarantees because they are always being violated. But yes, we have, in terms of legal terms, we can allege this. We can sustain the fact that this was a violation of fundamental rights. But it's really important to keep in mind something that was actually pointed out for the SSN in 2022. The targets, the tracks, and the traces. So who are usually those who are under surveillance? Yes, everyone is under surveillance, but which data collected from this surveillance will be used and for what and how? So it is essential to say that here in Brazil, I think in the Lava Jato scenario, we can see that criminal attorneys, usually attorneys in Brazil used to have some respect, but criminal attorneys, criminal defense attorney here in Lava Jato were also being under surveillance. So this kind of, there are some delicate points, that some specific subjects as criminal, as human rights defenders, as environmental and indigenous and traditional people, they are more vulnerable.
Thank you so much. And now I will want to ask the same question to Deborah. Like, I mean, with all these violations, are you moving forward and, like, launching a case in the U.S.? And what would be, like, the grounds? If you cannot talk about it, is fine. But we will love to know what will happen and whether this situation could help Julian Assange in his, like, a fight for justice.
Well, as I said, one of my biggest concerns was the lack of accountability for governments who abuse their powers and engage in illegal surveillance. And so what we're trying to do in the United States through a court proceeding is raise the issue of illegal surveillance and the impact that it will have on Julian Assange's chances of a fair trial in the United States. By bringing basically we have lawyers and journalists and possibly doctors who are United States citizens whose constitutional rights under the US Constitution as US citizens were violated by this illegal surveillance to the extent that the UC Global security people inside the embassy were directed and employed, arguably, certainly financed by the CIA or arms of the CIA. So essentially the lawyers, doctors, and journalists are going to be filing a constitutional lawsuit, hopefully in the coming week or two, suing Michael Pompeo, who was at the time the head of the CIA, as well as UC Global, and David Morales, who was the CEO of UC Global, and who was the person who was recruited by the CIA to be their main agent inside the embassy for handling the surveillance of Julian Assange and his visitors. And we're basically bringing a claim that this was a breach of the United States Constitution protection against illegal search and seizures under the Fourth Amendment, because as lawyers and journalists and doctors and any citizens of the United States, whether on US soil or abroad, we are protected, or supposed to be protected by our Constitution against illegal searches and seizures by the United States government. And so even though it wasn't literally a CIA agent in the embassy, these were agents of the CIA in the sense that they were acting under their instructions. And so we believe we have a valid constitutional claim there. And then in addition, we are filing a claim based on our First Amendment rights, because of the First Amendment protects United States citizens against unreasonable interference with their rights to free speech and freedom of the press and freedom of association. And to the extent that we were targeted based on our association with WikiLeaks and Julian Assange, to the extent that our reputation will be impacted by the fact that we can no longer be trusted as national security journalists and lawyers to keep information secure just because of our associations. This will have an enormous chilling effect, particularly for the journalists, on their rights to free speech and rights to freedom of the press to be able to broadcast and report on information that's embarrassing to the U.S. government. So we don't know if it'll be successful. It is it's a strong claim, but we are up against a very strong government, and we are hopeful that this case will bring attention to the enormous abuses that took place at the embassy.
Thank you. And the purpose of this panel was precisely that, to highlight how bad this situation is in a specific case, but also in general cases, and how we need to organize as lawyers and privacy activists and privacy experts against this. One of the recommendations after this panel that I'm proposing, and that I will invite probably many to sign, is a petition to the UN Special Rapporteur on Privacy to come together with the rapporteur in charge of the independence of lawyers of the judiciary at the UN level to do a joint work, a joint report. I think that would be very, very important on the privacy of lawyers. I think that it would be extremely relevant to count with this global analysis on how to protect better our rights. And maybe similarly to the global moratorium that we are seeking against surveillance technologies, we could push for a global rule when surveillance against lawyers is punished at a higher level because of the duty that we have in our hands. I will open the floor very quickly because I'm conscious of time for one or two questions from the audience, and let me know if you want to ask a question. And if not, we close. Yeah, because yeah. One second.
Thank you for the panel. It was really interesting. I just have a question about the last topic that you asked, and let me ask to you the question, because in the case that we're thinking about lawyers defending those who are more vulnerable, those who are more with less power, indigenous groups, people with in racial situation, etc. But what about lawyers who tend to be a tool for powerful people? And I'm asking the question, for example, tax lawyers. And it's interesting, the question of tax lawyers, because tax transactions, normally through a bank, need to be declared over a certain amount of money, and that is a mandatory surveillance, or legal surveillance. But we don't have something like that for lawyers, for example, and something that's a problem for Latin America, but it's not in the exception of national security, as you point. What happened with narco lawyers, tax narco lawyers? And those, at least in my country, I'm from Chile, are increasing a lot. Do you think there is kind of an exception of those kind of rules for those kind of lawyers, or they should be under the same protection?
I will leave it to the panelists for that question.
I think it's always trendy. It's dangerous to make exceptions because that's usually what they do with criminal defense attorneys, the criminalization of them. So I would say the laws are the same for all the lawyers and all the attorneys. I think the limits of the surveillance are the same. The independent body of supervision that should make any consideration of exception. And I would agree also with Ms. Deborah Herberg in terms of the lack of compliance, the lack of accountability. This is something that I think human rights compliance on part of governments can be improved in terms of transparency also. But I think all the transparency is a key word for democratic government. So I think this surveillance should be the limits of the surveillance should be the same, and also the fairness, transparency, accountability. These are some possibilities to build this human rights compliance of governments. Also to the exercise of lawyers. So I would say that, yes, it is important to assure also for these kinds of attorneys, due to the fact that in other way, we are in a dangerous way that this could be a criminalization of this kind of lawyers. So I would say that it is important to maintain for everyone.
Just adding to that, there's this phenomenon called lawfare, and tax laws all over the world in many cases have been used to silence activists and silence dissidents and silence people who are complicated for those in power. Deborah, do you want to add anything to that question?
Oops. No, I think you two covered it well. Thank you.
Any other question? There's one more question.
Very quickly, thank you for the panel. The topics are very interesting. I have a question. How about journalists and the lawyers related with the defense of journalists? In Mexico, we have two cases related with Pegasus and the surveillance of journalists. Thank you again.
That's again the Julian's case, so I leave it to Deborah as well.
Yes, this is a huge concern. I mean, honestly, I think that in a way, the illegal surveillance of journalists is almost more concerning than of any other of lawyers, to the extent that journalists are not going to report on abuses, human rights abuses of governments, and potential sources are not going to be confident in blowing the whistle and leaking information and telling what they know to journalists if there's no accountability for illegal government surveillance. People's lives will be put at risk. So this is a huge concern, and the big problem that we have, though, in all of these situations, the United States government doesn't even submit to the authority of the International Criminal Court in Europe, or we have so many steps to go, because we need to, first of all, as Daniela said, have a body that's responsible for delineating a code that governments follow in terms of surveillance, and then enforcing that code. But even if you have laws that technically, international laws that technically restrain the activities of governments, it's very difficult to get them to actually comply, especially the more powerful governments, such as the United States.
I will also like to highlight the role of the private sector. In this case, NSO, the company behind Pegasus, and UC Global in the case of Assange. And before that, it was all the companies providing Film Fisher, for example, a previous Italian company in charge of providing the surveillance software. Many times it's a private security company, playing double role. I think that we need to also focus on private sector accountability when this happens, because it is obvious that there's a collaboration going on there to suppress. And in the case of journalists, I just want to add something very important, because in the case of a lawyer and criminal lawyer, and the client is the criminal lawyer, the client, and the family affected. In the case of a journalist, is everybody in society, removed, the right to know, and the chilling effects that has in reporting, in editors, in everybody. So it is, as Deborah said, greater harm. Well, any other question? Yeah.
Bernarda, I do want to just add, I think you make a really, really good point there, because one of the ways, the constitutional protections that are available to United States citizens are restricted to situations where you have state action. In other words, it's only government action that you can claim as unconstitutional. And so the US government has made a practice. This isn't the first time it's doing this, but basically in our situation with Julian Assange and WikiLeaks, they went not only through UC Global as a private contractor, but through the Las Vegas Sands, and Sheldon Adelson were involved in as a middle entity or middle person in the outreach to UC Global. And David Morales from UC Global became involved at a private security conference in the United States. So the levels of, the collaboration between the sort of private forces and corporate lobbying and power whose interests are aligned with government is very problematic, and it ends up masking the sort of protection that we do technically have under the Constitution of the United States.
It's also a topic that we need to address in Latin America with the proliferation of private security companies and private security companies for hire to surveil on people, and that's happening in Colombia, in Guatemala, in Panama, everywhere. I think that this case, as cases against environmental activists, as cases against journalists, as cases against activists against mining, is showing us is that we need to elevate we need to coordinate better. We need to better and more robust mechanisms to to declare surveillance unacceptable, and we need to advocate for a higher cost for them to surveil on us. With that note, if there's no further question, there's a question. Yeah, great. We have lots of questions. Yeah.
A quick one, I promise. After living what you went through and knowing what you know now, as lawyers, what kind of precautions do you take when you hear a client, talk to them, exchange documents? What do? We live in a world where digital surveillance is so hard to overcome. Is there something we can do in a practical way?
I want to get them. I really want to get them surveilling on me. I really want to collect the evidence so I can prosecute them. That's the point is, it is extremely difficult to guarantee to your client today that you are having private communications, and there's techniques around it. But what I want is to reach the level of accountability against them. So if I suspect that my telephone is infected with something, I know who I should go to, in this case, Amnesty Tech. They will take my telephone if I'm working in a public interest case, and they will do all the forensics. If I'm suspecting that, that they are entering my home, I try to, this kind of, I try to get them, I really, and you can get them in different ways. You can get them by, direct action against you. You can get them, and that's a little bit of the work that, different organizations advocating for transparency are doing with the budgets, looking who are they buying technology from and what for. And I think that they're leaving a lot of crumbles in the public procurement and the ways that a state acquires things. And sometimes they say, oh no, it's for criminal investigation. No, let's get them. I think that was the case of Pegasus. In Pegasus, the government of Mexico disclosed all the contracts. And that was extremely useful. I think that we need to unveil this. And I think that the way to end with this, I was before with the approach, and I mentioned yesterday at the opening remarks. I was before, entering in this broken building wearing a helmet, wearing protection, installing all these privacy apps. I refuse to do. Of course, I'm doing it because I'm not reckless or careless, but I refuse for the burden to be allocated on us. I think that we need to shift and hold them accountable and expose them. So those surveilling on the most vulnerable. Deborah, I don't know if you have anything to add?
No, I think you covered it. Thank you, Renata.
I would just add the fact that meanwhile, this is not happening, this shift. It is important to learn a lot of, study a lot of digital security. Because we are all vulnerable all the time, but mainly through the fact that we are not born in an era in which we were alphabetized in digital. So that's it.
And last thing, I think that what we are doing here, we need to make young lawyers aware of this and educate them to demand, a better, curricula in law school. The same way that ethics is very important for lawyers. I think that this should be a subject, understanding the vulnerabilities that we have to deal with when practicing law from the time that you are in law school is very, very useful. It's not only digital skills and how to do case management online, but is about what does it mean that your whole law firm could be served a national security letter, and all your files gone, because you have everything hosted in the U.S. And the U.S. will not recognize your, privilege as a lawyer if you are from a banana republic like me. So that's so many issues to dissect. That will be probably for the next panel in CPDP 2023, where we hope to have Deborah here in the room with a successful case, and we hope to us joining us as well to have the continuation of this panel, so we can tell you how the case went. Thank you very much. I think that we are almost in time, so I leave you some time in between for grabbing a coffee. And thank you so much for attending this panel, and thank you so much, Deborah, for staying with us so long, and for you to preparing such a good presentation and illustrating all the examples of Brazil. Again, apologies extended from the lawyers who couldn't make it, and see you next year here at CPDP 2023 for the second part of this one.